Welcome to James Madison's Montpelier. I'm Ryan Nobles from NBC 12 in Richmond, and we're continuing our conversation on the Bill of Rights. Joined by Police Chief Tim Longo from Charlottesville, who's also an attorney, Hank Chambers, who's a law professor at the University of Richmond, and Peter Irons, who's a widely published author and the political science professor emeritus at UC San Diego. We're going to talk now about the Eighth Amendment. And I'm going to start with you, Peter. From a historical perspective, what were some of the main concerns for Madison in addressing the Eighth Amendment?
The most obvious concern was that in most of the colonies, and of course this occurred in Europe as well, all over the world, really, there were punishments for crime that were just unbelievably torturous, and sentences, for example, in London during the 18th century, there were over 100 crimes for which people could be put to death. You know, just picking pockets, for example, stealing bread. So the severity of the punishment became quite an issue. And even after the Eighth Amendment was passed, interestingly, a number of states imposed various forms of corporal punishment. The state of Delaware, for example, allowed people to be punished by whipping them with a lash, and juveniles could be treated very harshly as well. So that was the main concern, that punishments were much too severe.
And Hank, as we look at it practically applied today, cruel and unusual punishment probably is in the eye of the beholder, is it not? How have the courts addressed that kind of very broad description that was put forth by the fathers?
You raise a good question. The notion of what's cruel and unusual today versus what was cruel and unusual a couple hundred years ago is a little bit different. And the idea is that we're supposed to think about what our standards of decency are today. What do we consider to be cruel and unusual today? And that becomes the standard, not necessarily what was done in the past. Now, some justices have taken the position that no, cruel and unusual should be thought of in the context of back then. But most folks say, no, really need to look at today and how we punish people today in terms of trying to figure out what really qualifies as cruel and unusual and as a consequence unconstitutional under the Eighth Amendment.
And as somebody who's a constitutional scholar and also a law enforcement guy, Chief, do you think that cruel and unusual punishment could be used as a deterrent from people creating crimes? And should that be applied in the way that we view the standard?
Deterrence and retribution always come to mind when you think about punishment generally. Mm-hmm. But I also think there's an issue of, and I think from time to time we wrestle with this issue of proportionality. Mm-hmm. The punishment fits the crime, so to speak. And you know, today we look at the death penalty, for example, kind of being that option reserved for people that have been charged with the most egregious of offenses, such as murder. Mm-hmm. And I think this issue of what society today is looking at and saying, well, that's you know, consistent with notions of decency. And it's most topical in this issue with what to do with juveniles. Mm-hmm. Which is really where it most comes out, and the courts are looking at not only what the states are doing, the state legislatures, they're looking at sentencing things that have occurred in the past, but then they're also interjecting somewhat their own judgment as well and making determinations as to what's cruel and unusual or not.
Right, and capital punishment, Peter, probably the most obvious example of the controversy surrounding the subjective nature of cruel and unusual punishment. How has capital punishment been the perfect example of how the evolution of the decency standard has changed over time?
Well, it's interesting because this goes back, and Hank mentioned this, the concept of evolving standards of decency. This is a phrase that came out of an opinion by Chief Justice Warren back in the 50s. It actually had nothing to do with capital punishment. A soldier during World War II had walked away from his base and then in North Africa decided it was too damn hot out there and walked back, and was charged with desertion. And then later, the government tried to strip him of his citizenship because of that. And Warren said, no, that's too severe a punishment. He'd already served 30 days in the stockade for walking away. To add that additional punishment violated what Warren called evolving standards of decency. Now, we got to a point with capital punishment, and the majority of public still, but by a smaller margin than before, supports the notion of capital punishment. But we have narrowed its application so much. For example, juveniles cannot be executed. Mentally retarded people cannot be executed. Mentally ill people cannot be executed. And juries are increasingly unwilling to impose the death penalty in cases. The number of death penalties, in fact, has dropped by more than half in the last couple of decades. So we're getting to a point, we may not get to that point because 35 states still allow for the death penalty, but its application is going down as people realize that we don't just single out the worst of the worst. It's done in many cases very arbitrarily.
Obviously, Hank, then that would indicate that the standard of decency is varying from state to state, correct? I mean, different states apply that standard differently.
They do vary from state to state, in particular, in terms of the particular crimes that folks want to use to trigger the death penalty. However, there has to be recognition that the Supreme Court's position is we're going to apply the same standard of decency to every state. So even though Louisiana might very well do things differently than Virginia, and I guarantee you they do, we're still going to require both of them to at least play by the same rules in terms of death penalty and what crimes qualify as being death eligible.
Okay. Gentlemen, thank you.
Thank you.
Thank you.